So, dear colleagues and friends, welcome to this discussion on human rights in the arms trade, legal risks, responsibility, and the role of institutional investors, which is co-convened by the Geneva Peacebuilding Platform, the Heartland Initiative, the Essex Business and Human Rights Project, and St. Mary's University in Texas. My name is Florence Foster. I'm a special advisor for the Geneva Peacebuilding Platform, but also an LLM candidate at the Geneva Academy here in Geneva. And I'm joined here by Tara Van Ho, Associate Professor of Law at St. Mary's University in Texas, who will present her research on human rights responsibilities of the arms industry, regulating states, and the investors that support them. I'm also joined by Anil Yilmaz Vastaris, Senior Lecturer at Essex Law School and Human Rights Center, who will reflect on Dr. Van Ho's findings as they relate to broader considerations of the business-state nexus in situations of armed conflict. Last but not least, I'm also joined by Sam Jones, President of Heartland Initiative, who will be reflecting on how the blurring of the defense and tech industries, the famous defense tech nexus, is reshaping historic investor approaches to the sector. Just a little bit of housekeeping. We'll be spending the next 40 minutes with our speakers, drilling deeper into some of these issues, and then open up to a discussion with you all. Please note that this first section will be recorded, and then we will stop recording for the Q&A section, but we'll try and provide a transcript version of that, or at least a summary of the Q&A along with the recording, following the Chatham House rule. If you haven't done so through the registration, please do send questions and comments in the comments feed that we have open for you. You will have a chance to unmute and actually voice your questions as well in the Q&A. So either or is fine, but do have some questions for our speakers to have it as interactive as possible. Speaking of interactive, we've kept this meeting as a meeting format, not webinar. So please work with us and don't unmute in the middle of one of our speakers' interventions, not least that it disrupts our speakers, but it's also recorded. So you will actually be heard in the recording itself. If you don't abide by those rules, either Rich or I will actually force mute you. So either way, we'll try and make this work. But now to sort of dig deeper and dive straight into the substance. As already stated in the event outline, recent developments in international law and practice are reshaping how responsibility for human rights violations in conflict setting is understood, not only for states, but also for businesses and financial actors. Frameworks such as the Arms Trade Treaty, the UN Guiding Principles for the UN Guiding Principles on Business and Human Rights are increasingly intersecting in ways that carry significant implications for institutional investors. This session examines how evolving legal standards are transforming human rights impacts associated with investment in defense industries, from ethical considerations into material risks and potential liability for investor portfolios. So this is the end of my blurb. We'll be digging now into some of these issues with the speakers. Tara, we first met, and I'm sad to say, nearly a decade ago now, when you spoke of the UNGPs in the context of a side event at the Arms Trade Treaty. You could hear a pin drop in the stunned silence. And this is not because everybody could relate to the UNGPs, but because some of them were asking, what are these guiding principles you're talking about? We've come a long way since, and at least I hope so. So let's first of all discuss the high level. How do you define businesses engaged in the arms trade? And what did you find is required of those businesses? And how does that relate to states' arms export regime? Over to you.
Thanks, Flo, and thanks to all of you for joining. It's nice to see so many familiar names in the list of participants. So from a high level, I first define businesses in the arms trade broadly to mean anyone who is producing, supplying, or otherwise engaged in conventional weapons, munitions, parts to those weapons, components of those weapons, as well as unconventional weapons. So drones have become, I think, as everyone knows, the main part of warfare in Russia, Ukraine, and also has played a significant role in the US-Iran conflicts. So drones are in, cloud-based software is in, semiconductors are in, and I see Robert McCorkdale is in the room. The UN Working Group on Business and Human Rights has also talked about this, and Caterpillar's equipment that is used to destroy homes in Gaza and the West Bank is in, right? If something is being used as a weapon of war, it falls within this broader understanding of the arms trade. And if it's financing, supporting, or otherwise facilitating those weapons of war, it also falls within this broader understanding of the arms trade. So it's a little bit of a bigger definition than what you have in the arms trade treaty itself. And that reflects really what the guiding principles themselves say, which is any business at any time, regardless of structure, size, mode of operations, are captured by the UN guiding principles on business and human rights. And what those principles say is that businesses have an independent and complementary responsibility to respect human rights that operates regardless of whether or not a state takes action to regulate the corporation itself or the business entity. So businesses have this responsibility to respect, and it means to refrain from harming human rights through their activities, operations, as well as their relationships. To do this, businesses are expected to undertake what's known as human rights due diligence. This is an ongoing and iterative process by which the business with stakeholders identifies real and potential risks that the business will harm human rights. The business then has to develop mitigatory plans as well as reparations and remedy avenues. So plans in which you can reduce the harm, as well as plans to repair harm that has already occurred. Once the business has finished one round of this, it's expected to start again. What did it learn from that first experience? What does it need to modify in terms of its operations? What else are stakeholders telling it about the risks that they face from the product's operations or relationships? Where a business has caused or contributed to an adverse impact, meaning a harm for human rights, then they're expected to provide remedies and reparations. And if they're only directly linked to those harms, then they have to engage and use their leverage to affect change in business partners, and that can include state actors. So that's the norm expected of all businesses, but any business that's engaged in a conflict-affected area, and by its nature, that means any corporation engaged in the arms trade, because where do arms go but for generally high-risk situations? Conflict-affected and high-risk areas require what we know as heightened human rights due diligence. That's where you consider not just the immediate impacts on human rights, but also what kinds of conditions are you creating in terms of the risk of a conflict arising? Are you facilitating a trade in weapons that will actually help facilitate widespread human rights abuses, giving rise to a non-international armed conflict? There's also an issue of the start of international armed conflicts. So when we talk about heightened human rights due diligence, you should also be looking at, is this a state or a customer who has in the past routinely breached the UN Charter? And if so, then you're at a risk there of, by providing them weapons, facilitating further invasions in breach of the UN Charter. And all of that ends up creating adverse impacts on human rights. So arms companies need to take account of all of that in determining whether or not they can sell their products to their clients. And that responsibility operates, as I said before, independent of the state's obligations or the state's willingness to meet its international obligations. So this runs alongside the Arms Trade Treaty, and businesses that are really taking their human rights responsibilities seriously shouldn't even be applying for an arms export license until they've done this kind of work first and determined that they can responsibly sell their weapons on. Once they've made that determination, they have to constantly review this. Sometimes states give arms export licenses that have a very long length in time. You know, we've heard of the forever licenses that come out of the Netherlands where there's no time limit to that license. That might give you a legal avenue within your own state, but it doesn't meet your human rights responsibilities if you're not continually reassessing whether or not that license, whether or not the use of that license is an appropriate use of your corporate responsibility.
Thank you, Ray, for giving that overview and really bringing in the different communities of practice that might be on this call today, from the arms trade to those who are more closely sort of used to talking the business speak and really trying to tie those pieces together. In what you've just mentioned, but also it comes across really strongly in the pieces that you've written, is sort of this forward-looking risk assessment. And you said several times in your talk just today, making a determination, and that's really central. Can you explain how a business can determine if a risk is actually predictable or not? And what does that mean here? Is it just complying to IHL? Is it one or the other? Perhaps elaborate a little bit on those points.
Thanks, Flo. So when we talk about businesses that cause or contribute to a harm versus those that are only directly linked to the harm, I use 5 indicators that I developed in an earlier piece, and I will share PDFs of all the articles, as well as a letter that Anil and I sent to the Committee on Economic, Social, and Cultural Rights last week as part of their consultation around the covenant in armed conflict, as well as a draft briefing report for institutional investors. And I'll share all of that as we move into the Q&A section. But when it comes to what do we expect of them, the 5 factors that I think are the right factors for assessing your relationship to harm is your power, meaning either your power directly over the harm, your power over another party, so your relational power to your business partners, and that could include the state, and your power over the environmental conditions giving rise to harms. And then there's independence. So your ability to leave a situation or a relationship, your ability to stop the harm from coming about in the first place. Those 2 will help initially situate a business's responsibility. And then on top of that, if you're sort of in the middle, there are going to be some times where you can tell very clearly the business is causing a relationship, and sometimes where you can tell very clearly the business is only directly linked to the relationship. Most of the time, though, you're going to probably end up, unless it's in your direct operations, you're going to end up in a position where it's not clear if you're directly linked to or causing. And there you have to consider the severity and predictability of the harm, as well as any mitigatory measures that the business has adopted. And this is where human rights due diligence can actually play a significant role in keeping you at the directly linked to stage rather than the contribution. When we have severity with armed conflict, it's always if it's a breach of human rights in armed conflict, it is going to be a severe harm. And there's a level to which within the arms trade, there's also a predictability always, because that weapons can be misused. They can also be diverted. And so how do you kind of adopt mitigatory measures and really assess the likelihood that your weapons will be misused or will be diverted? And that question comes down to what's happened in the past, right? So oftentimes conflicts are not as surprising as people make them sound when they first ignite. There's a pattern of activity that leads up to a conflict. And so particularly with international armed conflicts, so conflicts that occur between 2 states, you're looking at what have they done in the past. We tend to find that the same states are repeat violators of the UN Charter. And they're relatively predictable that if you are supplying arms to that state, you are likely going to be supplying arms to the start of an armed conflict. And I think Russia is a very strong example of that. The United States is another example of that. And so in the articles that I'll share, in one, I look at a company that supplied insulation to Russia for use in its warships. And in the other, I talk about the fact that the US has now breached the UN Charter 6 times in January of this year alone. It breached it again when it invaded Iran. We're in a situation where I don't believe anyone can actually sell weapons to the United States anymore or transfer weapons to the United States anymore while abiding by their human rights responsibilities. And that's because what the United States has evidenced is a pattern of practice that suggests that in the future it will continue to breach international law in its activities. When it comes to non-international armed conflicts, there are a few more factors that you need to consider. So we know that, first of all, conflicts generally, if they're going to last for peace, it takes 14 years before that peace really solidifies. That's the average length of time before a conflict reignites or a new conflict emerges within the same area. So you're looking at a long-term history, 14 years for that, 20 years for issues around authoritarianism. And that's because democratic transitions generally also take about 20 years before they solidify. they're most at risk in that period of time. And so during those periods of time, you should be looking at what kinds of power inequalities are there between groups of people on the ground? Can you easily identify one side of a political conflict from the other side of a political conflict, or one side from a social conflict from the other side? And if so, what then do we know about the kinds of inequalities that these people have? Can you tell that one part has a lot of political power, a lot of economic power, cultural, social power? If so, if there's an imbalance there, that's a really strong indicator of an emerging conflict. And you should start using your heightened human rights due diligence at that point and really start asking questions. Now, the natural next question everybody asks is, does that mean that you can't sell weapons to people or to places where there are indicators? And I promise, Flo, this is my last point on this question. And the answer is you can potentially if you have adequate human rights due diligence and really good mitigatory measures.
Thank you. And I think that really answers the question of, is it just IHL? Well, it isn't. There's sort of a broader pattern of socioeconomic factors. You talk about power dynamics when it comes to the broader challenges, when it comes to human rights per se. And I think that's really useful to sort of navigate that space. It is about risks and what risks you're willing to take and what potential legal slash financial slash reputational damages you're willing to take on. And when I say all of that, it's also really cognizant of the fact that people get into harm's way between one and the other, right?
Yes.
So I think it's really interesting to see what the different parameters are. And I really highly recommend you to read the sort of the long read of the 5 indicators. It really gives you a sense of what how to navigate that space. You also mentioned in the first part of your intervention how broad the sort of arms sector or the arms trade that you're looking into in your research. And that really takes me to the central point of this discussion today. It's really the institutional investors. So what does this all mean for institutional investors and who want to actually invest ethically? I have a personal bugbear with that word, but we'll get to that perhaps in the Q&A. But also who worry about their fiduciary duties to stakeholders. So a few words on that, and then we'll move on to some of the critical speakers that we've brought on board.
Yeah, so institutional investors are like all other businesses. They have their own distinct human rights responsibilities that attaches to what they do with their investees. Where a business is thinking about getting into investing in an arms company, the first question is, from me, is why? And generally, they will point to their fiduciary duty. And we can talk a little bit more about the fiduciary duty and the question and answer period, but there isn't a uniform global fiduciary duty for institutional investors. It's going to be very dependent on your own state's laws. So I'm going to suggest you talk to your own legal team because I have put my own legal degree in active status for now. But you are also talking about there's this assumption that means they have to pursue a particular course of action. And that's really true of a fiduciary duty. There are a lot of fiduciary duties and a lot of states that have fiduciary duties that are not always about only pursuing what's in the best financial interest. Sometimes you're allowed to take into account other factors, including human rights or the environment. More importantly, part of your responsibility as a business is to undergo this process. So you should be having this conversation with any potential investees, particularly in such a high risk sector. This is an area that should be prioritized for your own human rights due diligence. You should be talking about what kinds of human rights and heightened human rights due diligence are they undertaking. You should be talking about what kinds of mitigatory measures do they have in place. And that should all occur before you invest in something that's as high risk as this is. I am also often asked, and I have a briefing document that you will all see where I answer this question, which is there a company you recommend I invest in for this area? If I want to get into this, if I'm feeling the pressure from people to get into this, is there a company that is the right company? And the answer right now is no. I've been doing this, as Flo mentioned, it's been now over 10 years. I think it was 2015 when we started doing this. And I've talked to a lot of arms companies. And most of them will tell you that even when they have really robust human rights due diligence processes on their commercial side, they don't actually apply that to their military and defense side. So there's very little being done from the arms companies right now. They are paying attention to the conversation. They're aware of this because we've been telling them for 11 years, but they haven't actually started to move their commercial side into their arms and defense side work. And those are the good companies. Those are the ones that actually do have their human rights due diligence systems in place on the commercial side. There isn't a company that I'm aware of that is actually actively engaged the way that they're supposed to, developing the kinds of mitigatory measures that they're supposed to, and really following through on the remedial responsibilities that would give me the confidence to say this is a company that you can invest in responsibly and in line with your human rights due diligence processes. Now, I say that with a bit of a caveat. Anthropic has recently stood up to the US Department of Defense, as it still remains legislatively known. I'm going to watch how that plays out, and possibly we will have a new leader in this sector. But even with that status, there's some serious questions around what Anthropic is doing in terms of the pre-conflict and the post-conflict phases.
Thanks a lot. And we'll get to the sort of slippery slope of some of the sort of the tech sector that has moved towards the defense and how investors who previously invested in non-defense related businesses find themselves either surprisingly or unsurprisingly, depending on how pessimistic you are about this sector, faced with risks that they hadn't previously calculated. And I think Sam will be able to respond to some of that to complete that scenario building. But now turning to you, Anil. So you've worked a lot with Tara, so you know some of her work and her most recent papers in and out. But so digging a little bit deeper in her paper, Tara explains the various scenarios under which a business in the arms industry or producer of dual-use products or their investors might be contributing or directly linked to harm. In the former situation, the business is expected to remediate the harm it has contributed to, and in the latter, it can support remediation. What are the actual challenges to and opportunities for enhancing remediation of harms in this context? Over to you, Anil.
Thank you, Florence, and thank you, Tara. So I'm going to just talk a little bit about reparations because obviously the UN guiding principles, as well as Tara in her paper, talks about the step of repairing the harm that has occurred. And business and human rights frameworks typically, I guess, conceptualize this, the harm, but also the reparation for the harm as kind of that there is a clear victim or there is a clear set of victims. There is an individual victim and there is a causal link between potentially or a link of contribution between the harm and the business. But when we think about armed conflict situations, what we often obviously see are serious and widespread violations. We see obviously individual as well as collective harm here as well, but the victims are many and the harms are diffused and widespread. So it might be more challenging even for the willing companies who are serious about their human rights responsibilities and are interested and willing to repair the harm to actually go about it. It might also be difficult to often have that causal link, drawn between the harm and the perpetrators, individual perpetrators. And if we think about the arms industry or investors, or if we think about companies that produce and sell these types of dual-use products, they're going to be obviously one kind of actor that contributed or caused or is linked to the harms that we're seeing, diffuse harms, diffuse perpetrators in a way. So then, how do we draw those links, and how can businesses go about repairing these harms when you have, both the responsible parties might be diffuse, but there might be multiple contributions, but also the harms themselves are widespread and they're also continuous. There's a continuous nature of violations in armed conflict situations that may again render it quite challenging to draw those connections between the business conduct and the harm and the victims themselves. But I don't think the responsibility to remediate should cease because there might be other actors that are responsible, potentially, for the harms, or that it's difficult to identify which arms or which of the, you might be an investor that has invested in an arms company or in another company that provides dual use products, or a technology company that provides kind of military technologies that might have had multiple types of involvement in harms. So it might not necessarily be easy to identify what you should repair or which victims you should engage with. So in that sense, this can be challenging, but it doesn't mean that businesses can just simply say, well, this is too difficult to deal with. There are ways in which businesses can take steps to remediate and repair these harms. Obviously, where a causal link is clear, the causal link is clear, then business should take steps because their heightened human rights due diligence should give them some indication of potentially those clear links between their products or their transactions and specific harms. So in those cases, they can see much more clearly the groups that they need to remediate. But when those links when the connections are blurred, there are ways in which businesses can contribute to reparations. Now, if we first actually think about clear links where we might have a clear connection between products or arms or other types of products and the victims and the harms, it can still be further challenging to repair those harms. Again, even if the business is willing, because it may be simply challenging to provide compensation. If we think about potentially victims in Gaza, there are serious challenges in terms of even engaging with rights holders, with communities. And that obviously engaging with communities, rights holders, victims in the context of developing reparations programs is essential. And you might have barriers to properly engaging or operationalizing a reparations program or any type of kind of an effort to provide reparations because of other constraining factors that exist in a conflict-affected area. But where the lines are blurred and that there isn't a clear kind of connection between your products or your investments and a specific set of victims, there are still other ways to contribute to reparations. There might be transitional justice mechanisms that businesses can engage in and contribute to. And we're not only talking about, obviously, we're not only talking about compensation. Reparations are obviously broader than that. Acknowledgement of wrongdoing, other types of, non-recurrence, guarantees of non-recurrence, restitution, rehabilitation are all part of a reparations program, reparations that businesses can support. And another thing that businesses can engage in and should adopt as a practice is just simply not to obstruct when people are seeking reparations, when victims are engaging in processes or in litigation or other types of grievance mechanisms. We are seeing powerful companies filing SLAPP suits, lawsuits against human rights defenders. We're seeing kind of other types of obstructing pathways to remedies. So they could simply not do that. I think that is a very good start as well. And then also, I think for investors specifically, they need to also think about the rights holders. Obviously, they're the primary constituency, the individuals that have been harmed or the communities, but also the beneficiaries. I'm saying this as someone who holds, my pension fund is invested in multiple companies that support various wars around the world. So I think there's also another constituency that investors specifically need to consider, in institutional investors, when thinking about reparations. So I'm going to stop there. Thank you very much.
Thanks a lot. And Sam, I see you've come with your camera on, and Tara messaged me about 2 fingers that she desperately has on Anil's intervention. So I'll get to Tara in just a second. But I think it's really interesting what you mentioned, and it sort of ties in really nicely with the piece that Tara just said, that heightened human rights due diligence needs to be really baked in, not bolted on. It's a sentence that we've heard over and over again, and those who work in BHR are probably bored of it by now. But I think really embedding human rights due diligence and heightened when it comes to the high-risk sectors or regions is really important, because it not only gives you the chance to mitigate the harm, so to prevent it from happening in the first place by either stopping to do business in that area or in that industry or investing in it, but also importantly, sort of finding the pathways of what do you do when things go wrong. Because they can go wrong in any sector, and in the arms sector particularly, there's a heightened risk of that happening. So really not thinking of it once the harm is done and sort of scrambling away and potentially reacting, as Anil has pointed to, fairly sort of the knee-jerk reaction is a slap suit, is to shut down rather than engage. So I think that's really an important complementary point that you're making. But Tara, you wanted to come in on a point that I actually noted down here on my little notepad, where I'm trying to track some of the interesting nuggets to bring back in the Q&A. Is sort of one thing that comes again and again in the arms trade world, and closer to the arms trade treaty itself, is sort of the directness between a weapon system being exported and the harm, and whether or not that's the strictest sense, where liability for the ICL among us or responsibility for the IHRLers amongst us sort of lies. And I know you wanted to just pick up on that point, because it's also something that Anil mentioned.
Yeah, so there's a few things to think about in this, and it relates a little bit to the fiduciary duty issue. First of all, if you're getting to a point where you're having to decide, did I cause and contribute, or was I only directly linked to a harm? Something went awry in your human rights due diligence. Probably 90% of the time, that's true. There's always going to be an exception. My example is always, if tomorrow Sweden invaded Norway, I'm not going to blame any of the arms companies that sold weapons to Sweden for that invasion, because it's completely unpredictable and outside of what even the best analysts would anticipate. But generally speaking, something has gone awry. And when it comes down to it, then what you're looking at is this causal link is deeply, the expectation that you need to show a causal link is deeply problematic from a business and human rights perspective. If you're creating weapons that are going into this kind of common pool of weaponry, and I talk about it in one of the pieces about the fungibility of arms, where lots of different kinds of weapons will be used, some of which may be used to commit war crimes, while others are used lawfully. Same thing with components and parts. If you're looking into that, you're supplying sort of that common pool of resources. And I think that can be a means of contributing to war crimes, even when your weapons haven't been used. So this is a very distinct thing from international criminal liability, where complicity requires the actual weapon to have been used to commit an actual crime, or actual goods to be used in that way. From a business and human rights perspective, it's a little bit broader than that. So you should be looking at not just, has my individual weapon been used, but has my supply been used to sort of create this common pool that is facilitating war crimes, crimes against humanity, genocide, or serious violations of human rights. And within that, it's important to note that victims are also looking at ways to get around that sort of direct causal link. There's a really interesting case in Texas right now. I'm floored that it's in the state that I just moved to, but they're suing Texas Instruments and Intel, along with a couple other companies, because their semiconductors that they produced were diverted through the supply chain and ended up in Iranian-made drones. And the question that I know that the defense is going to ask is, how can you prove that it was our particular semiconductors that were used in these particular weapons that caused this particular harm? That causal link that Anil pointed out. And first of all, I don't think that that's the right test for this kind of a situation, even in tort law. But more importantly, from a business and human rights perspective, that cannot be the situation that you rely on. It cannot be from a business and human rights perspective that a business invokes, oh, we don't know enough about the causal link, because that suggests that you just haven't set up your human rights due diligence appropriately and you're not working adequately to mitigate the risks from your components.
Thank you. And thanks, Sam, for bearing with us on that one. But now, turning to you, we met a few years ago when the Ukraine had just gone through its full-scale invasion by Russia, along with several other conflicts popping up on the horizon. And when we really tried to engage on the data side, the quality of the data and the different parameters of what that data should look like or could look like for CARA contexts, so conflict-affected and high-risk areas. But it was also how to navigate that increasing blurring of the lines from those who've typically been dubbed as sort of the typical tech industry to the slippery slope towards a more defense-like engagement, which is really reshaping historic investor approaches to the sector. So my first question to you, and I know some of you might have your your arguments at the ready for those who are tired of hearing of the data gap, but is it really a data gap? Or is it a political will gap? Is it a bit of both? Is it about translating one to the other and bridging these two worlds that tend to ignore each other, I guess? So yeah, over to you a little bit more about that. And then I have another question for you as well.
Yeah, thanks, Flo. And please let me know if there's any tech issues, and I'll go off camera to make sure that I'm coming through. Okay. So, categorical answer to the first question. There is not an absence of data. And I can say that unequivocally because that is what we in our team do every day, identifying data, analyzing data related to corporate proximity to human rights harms in conflict affected and high risk areas. I'm looking at the list of participants, and there are any number of organizations in this call upon whose data we rely upon, and then analyzing that. Now, is the data perfect? No. Is there varying degrees of quality of data? Yes, which is part of our responsibility in terms of when we're providing that data analysis to investment learning partners. But as I was reminded by one of those investment partners in London last week, investors are not expected to be attorneys. The preponderance of risk, the perception of risk, the if not at an evidence threshold, but the presence of risk is enough for investors to challenge companies, whether that's through engagement, whether that's through shareholder resolutions, whether that's through proxy voting or exclusion. That is sufficient. So first answer is that there is not an absence of data. What there is a lack of access and a lack of centralization to that data. Why is that? Because the vast majority of institutional investors around the world, be they ESG aligned or more mainstream, rely on a comparatively small universe of ESG data providers. Morningstar Sustainalytics, MSCI, ISS, et cetera. We're familiar with the names. There was always a methodological problem to their risk analysis, and that was that the concentration was on how does the environment where business activities is taking place impact the business versus how does the business impact rights holders on the ground. So that was a pre-existing issue. But as a lot of people are familiar with here, what happened in the States is that there was essentially both a public, in certain cases, and private surrender of ground on human rights and conflict data based on Israel-Palestine and the way in which that particular issue was politicized and weaponized within risk assessment methodologies, which created a broader ecosystem risk. So there is a lack of access. I mean, we are a small organization. We provide a lot of data, a lot of analysis, but we are not equipped to become the next Morningstar Sustainalytics, nor do we want to. We would like to work with leading responsible investors. There is an absence of political will. There is an absence of political will amongst companies. There is an absence of political will amongst investors to varying degrees. And what we're seeing by virtue of the Rearm Europe Act, by virtue of the Trump administration's actions related to various violations of international humanitarian law, pressure on NATO, um, by virtue of governments demanding and clients demanding that investors invest more in the defense industry, is a divergence between those companies and investors that are rushing into what is a both could be called a national security imperative, but is also a huge area of profitability versus those companies, investors that are still establishing, maintaining, and acting upon certain red lines, those being the systematic violations of international humanitarian, human rights, and criminal law in certain contexts. And so, for example, we see in the big tech space, you have Microsoft that terminated its contract with 8200 unit of the Israeli Defense Forces based on a violation of terms of reference, established a new internal whistleblower policy and platform on misuse. Now, there are still any number of risks for the company, not just in Israel and the OPT, but in broader, but in CARAs worldwide. But that was incremental and meaningful action versus an Alphabet who is quite literally using the Microsoft example to market themselves in a comparably favorable light, whereas we are not going to take punitive or disciplinary action or enforcement action based on a violation of those terms of reference. In fact, we're not even going to include a number of those terms of references in our contracts, having just degraded our own responsible AI use. So, and you see this in the investor community as well, where certain investors are taking principled action when it comes to the exclusion of certain companies like Palantir, where there is a huge disconnect between the company's global human rights policy and what they claim in engagement calls versus the statement of their C-suite executives versus what's being publicly reported upon in Gaza, in Ukraine, in the UK, in the United States, working with ICE. And so once those red lines have been crossed, certain investors are making the responsible decision to exclude. And so, yeah, not an absence of data. Yes, it is an absence of political will. And I think it's really important to not just look at it in terms of calling out. It's important to look at it in terms of publicly acknowledging when either companies or investors make those kinds of red line based decisions in an attempt to uphold international humanitarian, human rights, and criminal law. Not from a standpoint of that's the work has stopped there, but certainly to acknowledge it where it's being done, especially in this space. Yeah, so I'll stop there.
Thanks a lot. And you've already hinted to it, so the defense tech blurring and some of the risks associated to it. I wonder if you can unpack that before we get into the Q&A a little bit more. We've spoken about it a lot. Some of these industries who've typically looked at more sort of supply chain issues, etc., find themselves a little bit at a loss when, suddenly they're faced with situations of armed conflict classified as such or not. And what the risks are for that blurring, not just for investors, but a bit more broadly as well.
Yeah, so to start with sort of the investor piece, I don't know that it's possible to overstate just how the blurring of the defense and tech sectors has upended the responsible investment ecosystem. It's an overly simplistic sort of analysis of what it was before, but there was a relatively uniform approach when it came to responsible investment in the defense industry, which was we are going to exclude, and we're going to exclude on the basis of revenue thresholds. So if a company is the largest defense contractor in the world, or if they derive over 10% or 50% of their revenue from military related sales, we're going to exclude them. We're also going to exclude controversial weapons, those weapons that are fundamentally incompatible with international humanitarian law or whose use are heavily restricted as dictated by various UN treaty bodies. So now we're in a space where you have a rapidly expanding and rapidly diversifying global defense industry, including the entrance of countries where self-reporting is not prioritized, is not regulated, is not demanded, which makes revenue-based thresholds incredibly difficult. You now have also related to the revenue threshold with tech companies, large, medium, and small, getting more and more heavily into the defense space. But whether it's dual use or explicitly military use, how do you establish revenue thresholds and percentages by which we will exclude certain companies based on how far they've gone into military contracts? On the product side, first of all, you have decisions by states and by companies on what were once prohibited weapons, now and investors starting to change their approach to that. So, for example, if a company used to be there was a ban, for example, on investment in incendiary weapons like white phosphorus by an investor. Now it's like, okay, we'll tweak that a little bit to if it's more than 10% of the company's revenue is based on white phosphorus, then we'll exclude. You had the Biden administration sending cluster munitions to Ukraine, which sent signals to the market. Now you are seeing a resurgence in cluster munitions by companies. And then more fundamentally, if you look at, for any of us to think about a cluster munition or a landmine, it's easy to wrap your head around. With an autonomous weapon system that has multiple parts related to autonomy, lethality, or systems that could be fitted in the battlefield and turned into an offensive versus intelligence gathering system, what are investors supposed to do with that? So it's really created this massive and abrupt sort of chaos in the system. And so what was a uniform approach is now becoming an episodic sort of whack-a-mole approach. And in this case, and going back to the question on data, this is where we are really struggling in terms of ESG data providers providing information on military AI decision support systems, on autonomous weapon systems, on high-risk surveillance technologies deployed not only in conflict zones, but in authoritarian states and in traditional democracies. So it was for that reason last October, Heartland launched a working group on defense tech and responsible investment, and it is designed to carry with it 3 deliverables by the year's end. One, saliency materiality risk analysis framework on the highest risk versions of defense tech, so military AI, autonomous weapon systems, and surveillance. Number 2, a set of engagement questions for investors on policy, practice, and governance for defense tech companies, but also, and I would argue critically, on the product life cycle. So they are interrogating legal compliance from R&D all the way to end use. And then finally, a set of product and conduct-based exclusionary criteria that is more fit for purpose given this trend. So let me wrap up there.
Thanks a lot to all 3 of you for giving us a taste of how broad and sometimes tricky to unpack this area of work really is. So it might have blown some people's minds in the different directions that we've gone in the last sort of 45 minutes. But that's really the nature of the challenge is different bodies of law, different sectoral businesses themselves, but also different communities of practice that come with them that really need to mesh and talk about these issues to find ways forward. And as we've just mentioned, investors that typically didn't have to deal with these issues suddenly having to forcefully do so, not just because of the imminent harm to people, but also the imminent harm to portfolios. But now it's over to you. And Rich, if I could ask you to stop the recording now as promised.